Sacramento County Public Law Library and Civil Self-Help Center, 609 9th Street, Sacramento, California 95814. 916, 874-6012. Expunging criminal records. Clean up your criminal record. This guide includes instructions and sample forms. Links to download the fillable forms are at the end of this guide. Additional copies of this guide can be accessed at www.saclaw.org/expungement-guide. Background: expungement is a term used when referring to a process of cleaning up your criminal record. In this process, you request that the court reopen your criminal case, withdraw the plea or guilty verdict, dismiss the charges, and reclose the case without a conviction. In effect, you are no longer a convicted person. However, the case record itself will still exist, but the outcome of the case will no longer be your plea or conviction, but instead dismissed in the interests of justice, or IOJ. Not all convictions can be dismissed. Expungement is limited to cases in which the defendant convicted of a misdemeanor or a felony that could have been charged as a misdemeanor, and was sentenced to county jail time, probation, a fine, or a combination of those three. Additionally, the penal codes permitting expungement of criminal records expressly prohibit certain types of convictions from being dismissed. Most of these exceptions involve serious vehicle code violations, those that result in 2 or more points on your driving record, or sexual offenses against minors. For a detailed list of exceptions, see Penal Code PC Section 1203.4, PC Section 1203.4a, PC Section 1203.41 and PC 1203.49. The laws used in expungement are: 1. PC Section 1203.4 is used to expunge cases in which probation was part of the sentence. 2. PC Section 1203.4a is used to expunge cases in which there was no probation. 3. PC Section 1203.41 is used to expunge cases in which you were sentenced for a felony, yet you served time only in a county jail, and not in a state prison. 4. PC Section 17 is used to reduce a felony conviction to a misdemeanor, which can then be dismissed. Felonies meeting the criteria under PC Section 17 are often called wobblers, meaning they could be charged as either a felony or misdemeanor. 5. PC 1203.49 is used if your conviction was the result of being a victim of human trafficking. Solicitar esta guía en español. VLSP Criminal Records Expungement Clinic, www.vlsp.org/criminal.asp 916-551-2155-2411 Alhambra Boulevard. Saint 110 Services provided. Assistance with expunging criminal records, including early termination of probation. Appointments are made for the week on Monday mornings. The office opens at 8 a.m., and the line for APPTS begins forming at 6 a.m. Free assistance. www.saclaw.org. Greater than home greater than law 101. Disclaimer: this guide is intended as general information only. Your case may have factors requiring different procedures or forms. The information and instructions are provided for use in Sacramento County. Please keep in mind that each county may have different requirements. If you need further assistance, consult a lawyer. If you received a state prison term as your sentence, or were convicted of a felony that cannot be reduced to a misdemeanor, you will need to file paperwork for a certificate of rehabilitation, rather than a petition and order for dismissal. More information is available from the California Department of Corrections and Rehabilitation at www.cdcr.ca.gov/bof/pardons.html. Although your conviction may be dismissed, restrictions resulting from the conviction cannot. An expungement does not remove the conviction from your criminal history. California and FBI criminal history records will still show the conviction and the subsequent dismissal. Seal the court case file from public inspection. The court file remains public record. Reinstate your right to possess firearms. In some cases, reduction of a nonviolent felony to a misdemeanor may accomplish this. Relieve you of your duty to register as a sex offender. In some cases, this may be accomplished by a different motion to the court. Allow you to omit the conviction from applications for government-issued licenses. You must disclose your conviction and expungement in your license application. Allow you to omit the conviction from application for government employment. If you are applying for a government job, a job that requires security clearance, or a job that requires a government-issued license, certificate, or permit, you must disclose the conviction and expungement. Allow you to hold public office. If the conviction prevented you from doing so, prevent the conviction from being used to refuse or revoke a government license or permit, such as real estate license, teaching credential, security guard certificate, etc. Prevent the conviction from being used as a prior. The dismissed conviction can be used for determining sentencing enhancements in subsequent convictions. Prevent the conviction from being used by the DMV. Expunged convictions may be used to suspend or revoke driving privileges. Prevent the conviction from being used by U.S. Citizenship and Immigration Services. In many situations, an expunged conviction may be considered for removal or exclusion purposes. For most people, the benefits of an expungement far outweigh these restrictions. Under California Labor Code Lab, Section 432.7, employers cannot ask about arrests that did not end in conviction, convictions that have been judicially dismissed, or about any diversion or similar programs. If the employer is aware of any such arrests or programs, they cannot use this information to make hiring, promotion, or firing decisions. Once a conviction is expunged, it becomes an arrest that did not end in conviction. Legally, you may answer no to these types of questions when applying with a private employer. Keep in mind, though, that background checks typically go back 10 years, and employers can see that you had a conviction dismissed. Answering no may look dishonest. A better response may be yes, dismissed in the interests of justice. When applying for government employment, you must disclose the conviction and expungement. www.saclaw.org. Criminal records expungement. Greater than home greater than law 101. 2. www.saclaw.org/expungement-guide. Step-by-step instructions. Step 1. Determine if you are eligible for an expungement. To be eligible to expunge your conviction, you must meet all the following conditions. Your conviction must meet the guidelines described in PC Section 1203.4, PC Section 1203.4a, PC Section 1203.41, PC Section 17 or PC Section 1203.49. These code sections provide very specific guidelines about qualifying charges and sentences. Be sure to read those code sections carefully, because there are many exceptions. At least 1 year must have passed since your conviction. If you served your full sentence, you will need to wait 2 years before filing your petition under PC Section 1203.41. You must have completed the terms of your sentence. In most situations, the court will not grant an expungement until your sentence is complete. This means you have completed your period of incarceration and/or probation, and paid all fines, fees, and restitution in full. You must also appear at all DMV hearings, and pay all DMV fines and fees. If you wish to make a payment, or set up a payment plan, contact the Department of Revenue and Recovery (DRR) at one of these locations. 700 H Street 4100 Branch Center Drive Sacramento, California 95814 Sacramento, California 95827. DRR can also be reached at 916-875-7500 or drrmail@saccounty.net. See www.drrsaccounty.net/pages/default.aspx for more information. If you are still on probation for this or any other conviction, you may ask the court to terminate your probation early. For more information, see the step-by-step guide on filing a motion to terminate probation on our website at www.saclaw.org/motion-term-probation. You cannot be serving a sentence for any offense, or be charged with the commission of any other offense. If you are still on probation for another offense, you will need to complete the terms of that sentence, or have that probation terminated prior to petitioning for an expungement. For more information, see the step-by-step guide on filing a motion to terminate probation on our website at www.saclaw.org/motion-term-probation. Your probation for the conviction you're trying to expunge must not have been revoked, and not reinstated. Step 2. Determine which type of expungement applies to your situation. The type of expungement used depends on the original conviction and sentence. The information below will help you determine which type of expungement is right for you. Misdemeanor or infraction convictions. Probation ordered and completed. File a petition for dismissal under PC Section 1203.4. Probation ordered, but not yet completed. File a motion to terminate probation. See the step-by-step guide on filing a motion to terminate probation on our website at www.saclaw.org/motion-term-probation. If that is granted, file a petition for dismissal under PC Section 1203.4. www.saclaw.org. Criminal records expungement. Greater than home greater than law 101. 3. www.saclaw.org/expungement-guide.
2006. New Jersey Judiciary. How to expunge your criminal record. What is an expungement? New Jersey law provides a limited right to expungement. The purpose of New Jersey's expungement law is to give a person who has either one or very few convictions a fresh start. The law also provides for the removal of records of arrests where the arrest not end in a conviction. The New Jersey expungement law states in detail who is eligible for an expungement. You should review the current applicable provisions of NJSA 2C 52-1 et seq. To determine if you are eligible. An eligible person must prepare and file a petition for expungement. The petition for expungement must be filed in the Superior Court in the county where the arrest or prosecution took place. A judge then decides whether the person should be granted an expungement order. An expungement order means that, with some exceptions, the criminal proceedings never happened. In general, these materials provide basic information about how to clear DOF arrest or expunge a record of or conviction. They do not provide specific advice about a particular legal problem that you may have, and they are not a substitute for seeing a lawyer at times when you need one. If you encounter a problem, or are in doubt as to whether you need a lawyer, talk to one. Note: these materials have been prepared by the New Jersey Administrative Office of the Courts for use by self-represented litigants. The guide, instructions, and forms will be periodically updated as necessary to reflect current New Jersey statutes and court rules. The most recent version of the forms will be available at the county courthouse or on the judiciary's internet site www.njcourtsonline.com. However, you are ultimately responsible for the content of your court papers. Statute. Acknowledgement. The New Jersey Judiciary would like to acknowledge Legal Services of New Jersey for allowing us to modify their expungement guide. The work that you see in this pro se expungement package is largely a product of their efforts. 2. Things to think about before you represent yourself in court. Try to get a lawyer. The court system can be confusing, and it is a good idea to get a lawyer if you can. If you cannot afford a lawyer, you may wish to contact the Legal Services Program in your county to see if you qualify for free legal services. Their telephone number can be found in your local yellow pages under Legal Aid or Legal Services. If you do not qualify for free legal services and need help in locating an attorney, you can contact the Bar Association in your county. Their telephone number can also be found in your local yellow pages. Most county bar associations have a lawyer referral service. The County Bar Lawyer Referral Service can supply you with the names of attorneys in your area who usually are willing to handle your particular type of case. Such attorneys are sometimes willing to consult with people in your situation at a reduced fee. There are also a variety of organizations of minority lawyers throughout New Jersey, as well as organizations of lawyers who handle specialized types of cases. Ask your county court staff for a list of lawyer referral services that include these organizations. What you should expect if you represent yourself. While you have the right to represent yourself in court, you should not expect any special treatment, help, or attention from the court. You must still comply with the rules of the court, even if you are not familiar with them. 3. The following is a list of some things the court staff can and cannot do for you. Please read it carefully before asking the court staff for help. We can explain and answer questions about how the court works. We can tell you what the requirements are to have your case considered by the court. We can give you some information from your case file. We can provide you with samples of court forms that are available. We can provide you with guidance on how to fill out forms. We can usually answer questions about court deadlines. We cannot give you legal advice. Only your lawyer can give you legal advice. We cannot tell you whether or not you should bring your case to court. We cannot give you an opinion about what will happen if you bring your case to court. We cannot recommend a lawyer, but we can provide you with the telephone number of a local lawyer referral service. We cannot talk to the judge for you about what will happen in your case. We cannot let you talk to the judge outside of court. We cannot change an order issued by a judge. Keep copies of all papers. Make and keep for your safe copies of all completed forms and any canceled checks, money orders, sales receipts, bills, contract estimates, letters, leases, photographs, and other important documents that relate to your case. How to file for an order to expunge your criminal record. Locate your records. Order to prepare expungement petition and prove your eligibility, you will need to get the following information. The date of your arrest. The statutes and the offenses for which you were arrested or convicted. Note that if the offenses were reduced from the original charges, these will be different. The original indictment, accusation, state grand jury summons, warrant, or complaint docket number. INCD all, if more than one. The date of the disposition, which could be the date of the conviction, date of not guilty verdict or date of dismissal. The specific punishment or other disposition. If you had an attorney when you were arrested and charged, check first to see if he or she has this information in your case file. If so, this can save you quite a bit of time. If you must locate your records on your own for an indictable criminal conviction or arrest, contact the criminal case management office in the county where the arrest or conviction occurred, and take some personal identification, such as a 20. driver's license or a birth certificate. You might also contact the county prosecutor. A list of county prosecutors' offices with addresses and telephone numbers appears at the end of this guide. Explain that you are interested in expunging your records and ask for the information listed above, or ask to look at your file if this is permitted. You may also be able to find information you need on disorderly offenses by contacting the clerk of the municipal courts in which you were prosecuted or police department involved in your arrests. If you cannot get all of the information you need, contact your local police department where you live to make an appointment to have your fingerprints taken on a state applicant fingerprint card for the purpose of individual review or challenge of record. The numbered steps listed below had forms you will need to explain what fill out and what to with them. Specific directions on filling out each form appear before each of the attached forms. Follow these directions carefully. Each form should be typed or clearly printed on 3.5 by 11 inches white paper only. Forms may not be filed on a different size or color paper. Step 1. Request state police records. Form a request for state police records. Use this form to obtain a copy of your state police record if you don't have it. The state police record, also known as the rap sheet, will reflect any arrests, charges and dispositions. Note: the state police will have a record sheet only if you were fingerprinted when you were arrested. You were not fingerprinted, and only a complaint was signed against you when you were arrested. You will still have a record of the arrest to expunge at the police department, but you will not have a record sheet within the Division of State Police, State Bureau of Investigation. Step 2. Complete these forms. Form B. Petition for expungement. The petition for expungement states that you are requesting an expungement order and states why. You qualify. Fill out the PET expungement order by following the boxed instructions for Form B. 4. You must then file the petition in the county where you were arrested. If you were arrested in more than one county, contact the Criminal Case Management Office in either county and ask whether they will allow you to file for expungement of your entire record in that county. Next, you must complete the verification page and sign in the presence of a notary, as this page must bear a notary seal. Form C. Order for hearing. The order for hearing is used by the judge to schedule a hearing. The Superior Court judge assigned to your case will usually schedule a hearing between 35 and 60 days after he or she gets your petition. Fill out the order for hearing by following the boxed instructions for Form C. Form D. Expungement Order. The expungement order is the official document that will be signed by the judge if your petition for expungement is granted. Fill out the expungement order by following the boxed instructions for Form D. Step 3. File and serve the forms. Make 3 copies of your notarized petition for expungement Form B, order for hearing form, and proposed expungement order Form D. Form E. Cover letter. The cover letter is a form letter that describes to the County Criminal Case Management Office the contents of your package and the purpose of the enclosed forms. Fill in the blanks on the cover letter Form ED and attach the cover letter to the originals and the TW photocopies that you are filing. Keep 1 copy of each for your records. Include 2 large self-addressed envelopes with the appropriate postage stamped on each envelope. Mail this package to the Criminal Case Management Office in the county where the arrest and/or prosecution occurred. A list of the county offices where these forms should be mailed, along with telephone numbers, appears at the end of this guide. There is a filing fee of $52.50. Most offices do not accept personal checks, so you should include a money order or certified check made out to the state of NJ. Treasurer. Step 4. Distributing the filed copies. 1 copy of the petition for expungement, order for hearing, and the proposed final order, expungement order, will be mailed back to you marked, filed, and assigned net a docket number. The order for hearing will also state the time and the date for your hearing. Immediately after receiving the filed copies from the court, make at least 7 copies of the petition for expungement, order for hearing, and the proposed final order, expungement order. Mail 1 of each, immediately, via certified mail, return receipt requested, to each of the following